one of our past shows, we had an interview with Michael Kolenc, who's the campaign manager for Vote for Independent Maps, which is the Illinois effort to get on the ballot in Illinois and change the Constitution there, and among other things, create a redistricting commission to help solve the problem, the underlying problem, as some other states have done. Since we interviewed Mike, there's been some significant changes in Illinois. They did reach their signature goal. We'll talk about that a little. But they walked into a really, really difficult and a hard-fought court battle on a couple fronts, as it turns out. So we thought we'd revisit with Mike today how things went for the campaign from the time we left him, and then drill down into the court issues. So anyway, the redistricting is a really difficult issue, and Mike's agreed to join us today so we can pick up where we left off before and answer some questions and find out where things stand in Illinois. So Michael, welcome back to None of the Above. Thank you for your time today. When we last left you, I think didn't they say like an old TV show? When we last left them on the ranch, surrounded by the Indians, I think that's where we left you, on the ranch surrounded by the Indians. You were in the middle of your campaign. You were doing fundraising, and more importantly, you were trying to get on the ballot. So
that's right.
You were trying to get signatures to get on the ballot. I understand you made your signature goal. How did that work out?
Well, obviously you can see my post-campaign beard, so it obviously didn't work out the way that we all wanted it to. We were successful in gathering over 500,000 signatures, taking them down to Springfield, but essentially by a death of 1,000 cuts from the various things that the state did to us by way of our signatures and by way of a court challenge, we had to conclude the campaign, unfortunately.
All right, that's the snippet for the people that want to go to the refrigerator and get a glass of soda right now. But the longer version is, take us back. You set up this campaign, and the goal was to change the Illinois Constitution to create what?
We wanted to create an independent redistricting commission, really to take the power of drawing state maps out of the power of political leaders from both political parties and putting it in a bipartisan commission that was operating in a transparent fashion, in a fair fashion, drawing maps with nonpartisan criteria, keeping communities whole, keeping minority communities whole, really paying attention to how communities wanted to be represented in Springfield, rather than having political leaders use the map-making process to protect incumbents and to hurt political foes. So we worked through this process over the past year to collect signatures. We turned in our signatures prior to the deadline, and it's amazing the powers that be didn't like us so much that they actually sued us before we took our semi-truck of signatures down to Springfield. So it was a foreshadowing of the battle that was to come.
So tell us about this semi-truck. You had, what, 500 and some thousand signatures?
We had over 500,000 signatures. The state of Illinois required them to be bound in a single document. So we literally had a 27-foot-long book of petitions that we took down to Illinois.
Really?
Yeah.
Because you knew if you showed up and it wasn't in a single book, that would be an excuse to deny you, right?
They would have said, turn the truck around. No good. Yeah. So we followed the letter and the spirit of the law. It took probably 30 people to unload this book from the semi truck, but we did it. We got it in the door. They accepted it, and they started immediately disassembling it.
Just out of curiosity, I don't know what the history is in Illinois of other signature campaigns. How does accumulating 507,000 signatures compare to any other effort in the history of Illinois?
Yeah, so this year was a special or an odd year for Illinois. There was a term limits campaign that was also collecting signatures. They collected a little more signatures than we did, but this is not something that typically happens in Illinois. There is a very small part of the state constitution that actually allows you to amend it via the petition process. So there is a very small place where citizens can actually amend the Illinois Constitution, and we actually this is probably the first time in a generation that someone has actually submitted over 500,000 signatures at this level in the single bound document. There was also another campaign going on in the state that collected a little bit more than we did, so we were actually submitting signatures within days of each other. But this was the first time in quite a while that someone has done this.
And 500,000 signatures represents what portion of the registered voters? How many? What did?
Oh, I couldn't even tell you that. We had to collect about 8% of the number of people that voted in the prior gubernatorial election. So we needed about 298,000 signatures, valid signatures from registered Illinois voters to qualify for the ballot. So, you know, it was I don't know if you know this, but it was a pretty harsh winter in Illinois. It was the third coldest and snowiest winter. And we had, sometimes it was a little hard to collect signatures, but we worked our best. We worked with a lot of coalition partners like the League of Women Voters, Common Cause, PIRG, the Chamber of Commerce, really to collect those signatures from all across the state.
Well, it's amazing that you could do that, and I applaud you. So you needed just short of 300,000. You came up with a little over 500,000. Obviously, you collect tons of extra signatures because some of them are going to be found to not be good, et cetera, et cetera.
Absolutely.
And then you walk down there, and already by the time you're down there, there's a lawsuit to block you, correct?
Before we even put the petitions on the semi-truck, we had a lawsuit in our inbox, challenging the constitutional issue of the ballot measures. Yeah, we had a lawsuit waiting for us in our inbox. Even before we put the signatures on the semi-truck, really to challenge the constitutional issue at place, which was there is a very small frame where you can amend the Illinois state constitution. That is to make a structural and a procedural change with how the legislature works. We felt that we were making both a structural and a procedural change because we were amending an actual structure and a process within the legislative article of the state constitution. And, our lawyers and a team of reform-minded groups around the state had been working on this for 2 years. We were very confident that our measure would stand up to constitutional scrutiny. Unfortunately, at the end of the day, in circuit court in Cook County, Judge Mikva ruled that our measure fell slightly outside of it. She did say, though, in her ruling that this is a measure. This is a ballot measure can be crafted to do just what we were trying to do. So we actually got some really good legal guidance from her. And I think there are a lot of people that are really hungry and excited to do this again.
Now, I know you elected to not appeal her decision.
Correct.
Who made the decision to not appeal? Is that a group decision? How did that get made?
Yeah, it was really a group decision. This was a very, very broad-based coalition. There was not one person was not really in charge. This was a group of people, a group of individuals and organizations that from across the state that had a vested interest in the outcome of this, that had an interest in the future of Illinois, that had a financial interest in the campaign. And after, it was not an easy decision to come to. A lot of people had spent a lot of time and a lot of money on this, and it was a tough decision, but it was really the responsible decision we felt.
Now, I obviously was not part of your kitchen cabinet. I don't know the whole thought process. You said it was complicated and difficult. But you mentioned that, to a certain extent, the court decision at the trial court level is like a learning curve for you to learn from. Would it not have been possible to get the same learning experience at the Supreme Court level and have them kind of spoon feed you into what the defects might be to help you make it even better the next time?
Yeah, no, I mean, I will say from a manager's point of view, as a person that runs campaigns, lawyers are not cheap, and we always have to worry about paying our bills, and we thought it would have been irresponsible to continue to rack up legal bills and staff bills for an ultimate decision at the state Supreme Court, much less finding the funding to do such. As you can imagine, donors are very aware and very cognizant of news stories and clips, and it was going to make it very hard to raise money in a healthy enough pace to fully pay for a robust legal defense at the state Supreme Court. And that would have been a very long process. Had we gone to the state Supreme Court, we probably wouldn't have gotten a decision until near Labor Day, which would have been, a very long road to hoe.
And again, I'm sure you had some really smart people doing all the pros and cons, but as a casual observer and someone who actually lives in Colorado following on the internet, I thought you were winning the PR battle. So again, I was wondering if you had fought this a little longer, if that PR victory would have had some sustaining element to it.
Well, I appreciate you saying that we were winning the PR battle. That is something that we worked very, very hard on, cultivating those relationships across the state to make sure that we got our message out. And, at the end of the day, this was really a death by 1,000 cuts, because at the same time we were undergoing a court challenge, we were undergoing a challenge on the validity of our signatures. And there were many, many small things that the state did, willfully or not, that the state board did, willfully or not, that the state board of elections, the actual commission members did, willfully or not, that really was going to make it very hard for us to validate enough signatures to actually get on the ballot. So we were fighting a two-front war, and I think we learned a lot from that two-front battle that we had to go through. But it also goes back at the end of the day that we were able to accomplish something that no one thought we would be able to accomplish. People said we wouldn't be able to collect 100,000 signatures, much less 500,000. So I think people left, people into the campaign thinking we did everything we could to get on the ballot, that we fought a long, hard fight, that we stayed above the fray, and we really initiated a very strong media battle. And I think the groundwork is there, the activists are there to actually try this again in the very, very near future.
Well, I would expect that. Now, you mentioned this signature battle, so that never was concluded. Once you lost at trial court, you kind of pulled the plug on that one?
That's exactly right. These are expensive battles. We had, a team of lawyers that were working on the trial, and then lawyers that were working on the validity of signatures. For example, collecting notarized affidavits from people who the state said signatures didn't match was a huge task, a task so large that it was nearly impossible for us to take on. So once the state board determined that a signature didn't match, for whatever reason, it was nearly impossible to rehabilitate that signature. And I'll remind you that, people signed their voter registration cards, sometimes 5, 10, 20 years ago. And I don't know about you, but my signature has changed in the last 10 years. And, I'll add the fact that a lot of these signatures were collected on very snowy or very cold days on street corners while people were trying to hop on buses. And maybe their penmanship wasn't the first thing on their mind as they were trying to get to the office. So, like I said, this was really a death by 1,000 cuts on the signature front, really placing a high hurdle on the campaign that was really cost prohibitive at the end of the day.
Do you think you learned enough on that side to remedy that next time around?
Absolutely. Something that we always say in in campaign worlds, as far as the mechanics, is that early money is very, very important. And the earlier the money comes in for a campaign like this, the earlier we can really start with a robust petition gathering process. So when the bulk of the money comes in very late in the campaign, you're very rushed. And when you're doing things in a rushed fashion, it is easier to be sloppy or collect bad signatures, which at the end of the day, some of our signatures were bad. I still believe to this day that we had enough good signatures to make it to the ballot.
So I guess you feel that there will be enough energy around this issue, whether it's your exact group or another group, to revisit this, in 2 years?
Absolutely. I think we'll actually start sooner than that. We can start gathering signatures right now for 2016 if we had the resources to do so. It just needs a campaign vehicle. So right now, what a lot of partners will probably end up doing is really examining the language in the ballot measure, making sure that it fits within the legal constraints that Judge Mikva kind of guided us on, and then really working to learn from this campaign, and then starting anew. The volunteers are there, the activists are there, the donors are there, the organizations are there, and I think a Yes for Independent Maps campaign 2.0 will be much, much stronger and able to get this done in a quicker fashion.
So there's no time limit on signatures. In other words, you could start tomorrow and turn them in 5 years? I mean,
correct.
If it took 5 years to get enough signatures.
Yeah,
interesting. Well, I think one of the lessons, and there's many lessons I know you're going to learn from and grow from, is how much the incumbents do not want you to do this, and to what lengths they're going to go in terms of hiring attorneys and building up their own attack mode to stop you. Had you anticipated the ferocity of their effort, or?
We did, but there is always something to be said about someone faced with the prospect of losing power, and that's really what we saw in Illinois. And let's be clear, this was from Democrats and Republicans both. Our problems on the State Board of Election were partially because the Republican chair was essentially not following the guidance of the hearing officer. So there were Republicans and Democrats in Illinois that were really setting up roadblocks at every turn using, secretive money. We don't know how the opposition was funded. They never had to file any campaign finance reports, even though we had to file them all the time. So the status quo in the state really did not want this to happen, and that was very apparent, from the second they filed the lawsuit.
Well, interesting. So you have to declare your financial sources, but your opponents do not.
They did not have to, no.
Is there any legislative effort that you need between now and your next challenge to clear things up?
Yeah, we've actually heard from a state rep over in the Quad Cities, Representative Mike Smitty. He's actually a Democrat, one of our great endorsers and supporters. He actually is interested in introducing legislation in the next session to put this on the ballot. He actually wants to introduce a constitutional amendment which can originate with the state legislature to put an independent redistricting measure on the ballot. This coalition would probably welcome something like that. I don't speak for the organizations anymore, but I'm sure they would want to read and see what Representative Smitty has in mind. But he was a full supporter of this, of the independence, the transparency, and the fairness that this measure called for. And, I think people would welcome a full debate in Springfield about this.
Mike, I don't doubt that you're going to get your effort put back together, probably raise a lot of money and get a ton of signatures. I don't look for that bill to pass the legislature.
I don't either. I don't either.
Well, you've been a gentleman to give us your time again. I wish you well, and hopefully when we interview you again, we're going to be talking about a great success story in your end.
Let's hope so, Steve. Thank you.
Thank you. Have a great day.
You too.